State Complaint Procedures. State Complaint Procedures, 34 CFR Section 300.151 and 53A 15305. General. The Utah Legislature finds that it is in the best interest of students with disabilities to provide for a prompt and fair final resolution of disputes which may arise over educational programs and rights and responsibilities of students with disabilities, their parents, and public schools. 53A 15305-1. The USP has adopted procedures for resolving any complaint under the IDEA, including a complaint filed by an organization or individual from another state. The complaint must be filed with the USP State Director of Special Education in person, by U.S. mail, or by fax, and include the name of the school district or charter school in which the alleged violation occurred. The party filing the complaint must also forward a copy to the LE or public agency. If the parents or adult student are unable to file in writing, they may contact the LE or USP State Director of Special Education for assistance. 1. Upon receipt of a written IDEA state complaint by either the LE or the USP State Director of Special Education, the receiving party will notify the other agency within 1 business day, to ensure coordination of the process and copies received by both. The state complaint timeline begins when both parties have received copies. Remedies for denial of appropriate services. In resolving a complaint in which it has found a failure to provide appropriate services, the USP must address 1. How to remediate the denial of those services, including, as appropriate, the awarding of monetary reimbursement or other corrective action appropriate to the needs of the student. 2. Appropriate future provision of services for all students with disabilities. Minimum state complaint procedures. 34 CFR Section 300.152. Time limit and extension, minimum procedures, implementation. The USP State Director of Special Education shall resolve the complaint within 60 calendar days unless exceptional circumstances exist. An extension of time shall not exceed 10 calendar days. If an extension is necessary, the complainant and the LE or public agency shall be notified, in writing, by the USP Special Education Services section. Within this time limit, the USP State Director of Special Education shall 1. Carry out an independent on-site investigation, if the USP State Director of Special Education determines that such an investigation is necessary. 2. Give the complainant the opportunity to submit additional information, either orally or in writing, about the allegations in the complaint. 3. Review all relevant information and make a determination as to whether the LE is violating a requirement of the IDEA or if USP Special Education rules. 4. Issue a written decision to the complainant, with a copy sent to the LE Director of Special Education and either the school district superintendent or charter school administrator, that addresses each allegation in the complaint and contains a. Findings of facts and conclusions, and b. the reasons for the USP's final decisions. 5. Permit an extension of the time limit under Rule 4G.4.A of the USPSAR only if a. exceptional circumstances exist with respect to a particular complaint or b. the parents, adult student, and the LE involved agree to extend the time to engage in mediation, or to engage in other alternative means of dispute resolution available in the state. 6. Determine procedures for the effective implementation of the USP's final decision, if needed, including technical assistance activities, negotiations, and corrective actions to achieve compliance. Final decision. The complaint decision issued by the USP is the final action and is not subject to an appeal. If either party disagrees with the decision, their remedy is to file a due process complaint provided that the aggrieved party has the right to file a due process complaint on the issue with which the party disagrees. Filing a state complaint. 34 CFR Section 300.153. The complaint must include the following. 1. A statement that the LE or public agency has violated a requirement of the IDEA or the USP Special Education rules. 2. The facts on which the statement is based. 3. The signature and contact information for the complainant. 4. If alleging violations with respect to a specific student, a. the name and address of the residence of the student, b. the name of the school the student is attending, c. in the case of a homeless student, available contact information for the student and the name of the school the student is attending, d. a description of the nature of the problem of the student, including facts relating to the problem, and e. a proposed resolution of the problem to the extent known and available to the party at the time the complaint is received, as described in Rule 4E.1 of the USPSAR. The complaint must allege a violation that occurred not more than 1 year prior to the date that the complaint is received. Nothing in the state complaint process limits the ability of the LE to attempt to resolve the alleged violation directly with the complainant. However, The state will continue to act on the submitted complaint until a report is issued or the complaint is withdrawn. State complaints and due process hearings. If a written state complaint is received that is also the subject of a due process hearing under the due process hearing procedures, or contains multiple issues of which one or more are part of that hearing, the USP must set aside any part of the complaint that is being addressed in the hearing until its conclusion. Any issue in the complaint that is not a part of the due process hearing must be resolved using the time limit and complaint procedures described in this section. If an issue is raised in a complaint filed under this section that has previously been decided in a due process hearing involving the same parties, then the hearing decision is binding on that issue. The USP must inform both parties of this fact. A complaint alleging Leah's failure to implement a due process decision, however, must be submitted directly to the USP State Director of Special Education and resolved by the USP. Parents or adult students and other interested individuals, including parent training and information centers, independent living centers, protection and advocacy agencies, professional organizations, and other appropriate entities, shall be informed about these procedures through 1. Procedural safeguards notice provided by LE. 2. Presentations and other training events by USP staff conducted throughout the state. Due process complaint procedures. Filing a due process complaint, 34 CFR Section 300.507 and 53A 15305. General. The Utah Legislature finds that it is in the best interest of students with disabilities to provide for a prompt and fair final resolution of disputes which may arise over educational programs and rights and responsibilities of students with disabilities, their parents, and public schools. 53A 15305-1. Prior to seeking a hearing or other formal proceeding, the parties to a dispute under this section shall make a good faith effort to resolve the dispute informally at the school building level. If the dispute is not resolved, a party may request a due process hearing. 53A 15305-4. The due process complaint must allege a violation that occurred not more than 2 years before the date the parent or adult student or LE knew or should have known about the alleged action that forms the basis of the due process complaint, except if the parent or adult student was prevented from filing a due process complaint due to specific misrepresentations by the LE that it had resolved the problem forming the basis of the due process complaint, or the LE's withholding of information from the parent or adult student that was required under the IDEA to be provided to the parent. Advocates and legal representation. Persons with special expertise, including advocates, may assist or accompany either party to a due process hearing. The parties may 1. Be represented by an attorney authorized to practice law in the state of Utah, or 2. Represent themselves, also referred to as pro se representation, Utah Bar Rules 14-102-111, 14-802C. 8. Information for parents. The LE must inform the parent or adult student of any free or low-cost legal and other relevant services available in the area if the parent or adult student requests the information, or the parent or adult student or the LE requests a hearing under this section. Adult student or the LE requests a